Maine Secretary of State Shenna Bellows, a Democrat, does join me live. Thank you so much for taking the time to be here, Madam Secretary. I want to start with this op-ed from former U.S. Attorney General Barr. In it, he writes, quote, "The point is that in present-day America, under existing law, the only way to disqualify someone under Section 3 is through criminal prosecution under Section 2383. And in your ruling, you point that there is a lot of evidence that the former president engaged in insurrection. But how can you reach such a historic decision without a conviction? He hasn't been convicted of anything."
Good afternoon, and thank you for having me. So my 34-page decision is available on the Secretary of State's website. Let's be clear. The Constitution does not say convicted of engagement in insurrection. It says engage in insurrection. And in my decision, I detail the legal basis based on the facts presented at the hearing here in Maine. And there's something else that's really important. So Maine is unique in that we have this process whereby under Maine election law, the Secretary of State is obligated to ensure that every candidate meets the qualifications for the primary ballot. I had accepted Mr. Trump's petitions. Then under Maine law, any registered Maine voter can challenge the qualifications of any candidate within a 5-day window. And I was then obligated to hold a hearing and issue a decision. Now, this appeal to the court is part of the process. So Mr. Trump has his right to appeal this week. That's why I voluntarily suspended the effect of my decision pending court appeal. What's most important in this whole conversation is the Constitution and the rule of law. I swore an oath to uphold the Constitution. Maine election law required me to hold a hearing within 5 days, issue a decision within a week, and now is the next step, and that is the process in the courts. Now, with regards to interpretation of the Constitution, in my decision, I set forth the reasoning based on the facts presented to me in the hearing and legal arguments made at that hearing. Now the courts have an opportunity to make a determination, and I will uphold whatever the courts direct us to do.
And I read through the 34-page ruling that you put out now just a couple of days ago, and you did use the congressional January 6th report in that decision. Considering that report being from Congress is in many ways political, how can people be certain that your politics aren't part of your ruling in deciding that former President Trump should not be on the ballot?
No other consideration could be made except for the Constitution and the rule of law. My partisan affiliation, my personal views, my fears for my safety or anything of that sort, and in fact, my home was swatted on Friday night, and my staff, my team, my family have been targeted with aggressive and threatening communications in the wake of my decision. Those could not be considerations because of my oath to the Constitution. That was my sole consideration.
And I know you have had a difficult couple of days. I want to talk about that in just a moment, but why not let people decide whether former President Trump should be in office again? I know you talk about upholding the Constitution, but why step in when the people of Maine could decide whether or not they want him to be in office?
I didn't choose to intervene voluntarily. 5 registered Maine voters, including 2 former Republican state senators, brought a lawful challenge under Maine election law to the qualifications of Mr. Trump. We held an administrative hearing under Maine law where both sides were represented by counsel, attorneys, and were welcome to present witnesses, testimony, and exhibits. Mr. Trump chose to present no witnesses. Then, based exclusively on the record at that administrative hearing, I was required by law to issue a decision. It now goes to the courts. And I share that because that is the process under the law. And actually under Article 1 of the Constitution, the states are delegated the authority to administer elections. We have different voting rights laws. In fact, in Maine, we're very proud. We were #1 in the nation in 2022 in voter turnout. We have strong voting rights laws. But they also have different ballot access qualifications. For example, in New Hampshire, next door, President Joseph Biden is not going to be on the presidential primary ballot because of the process in New Hampshire. There'll be more than a dozen Democratic presidential candidates, but not Joseph Biden. Similarly, on the Republican side in New Hampshire, there'll be more than a dozen presidential candidates. In Maine, 2 Democratic presidential candidates qualified under our ballot access rules. And a week prior to issuing my decision on Mr. Trump, a Superior Court found that I made the correct decision in denying Mr. Chris Christie access to the ballot because he did not gather enough signatures here in our state to qualify. Now, I raise a question. Should someone present, an 18-year-old, a non-citizen, or say hypothetically Barack Obama or George W. Bush, sought to run for office in Maine? Under Maine law, I'm prohibited them from being placed on the ballot. And I raised this question in my decision, but I think it is crystal clear that I'm required by the Constitution and the law to ensure that candidates who appear on Maine's primary ballot meet the qualifications of the office. And constitutional requirements are not a menu of options. They are the first and foremost obligation and law of our great country.
But going back to the law, the Constitution, not saying that there needs to be a conviction, wouldn't a conviction be something set in stone to say he was convicted of an insurrection, where when you look at the decision that you've made, it was reviewing evidence that could be interpreted in many different ways?
In my decision, I make this very point. The record demonstrates that Mr. Trump engaged in insurrection of January 6th. It was really clear. And remember, the events of January 6th at the Capitol were not just an attack on the Capitol. They were not just attacks on government officials threatening and requiring the evacuation of members of Congress and threats against the former vice president. It was an attack on the rule of law, on the peaceful transfer of power. And the weight of the evidence, not just the January 6th report, which is bipartisan, but all of the evidence presented at the hearing, the weight of that evidence demonstrated that those events happened at the behest of and with the knowledge and support of the outgoing president. And the U.S. Constitution does not tolerate an assault on the foundations of our government. And Maine election law required me to act in response.
Assuming that this goes to the Supreme Court, how confident are you that the justices will see it your way?
I'm not going to predict what the courts might do because my obligation is to follow what the courts direct me to do. And that's what we will.
All right, Maine Secretary of State Shenna Bellows, thank you for your time.